Hi, I'm Keith Whittington, professor of law at Yale Law School, and I'm here to talk a bit about the First Amendment, in particular, the freedom of the press and the limits to what kinds of First Amendment protections there are to different things that one might say are right. And in particular, I want to talk today about um, obscene speech and offensive speech. Obscenity, in particular, has traditionally been regarded as one of the exceptions to the First Amendment. That is to say, when the First Amendment was written, protecting freedom of speech and freedom of the press, it was understood that that was not an absolute right, that there were some implicit limits on what kinds of freedom of speech and freedom of press you might have. And what constitutional law has been concerned with over the course of American history has been trying to explain what those limits are, try to think about how those limits are consistent with the goals and purposes and text and history of the First Amendment itself. Obscene speech had been long recognized as something that would be criminally punished, and as a consequence, not something that was consistent with or required by a freedom of speech or freedom of the press. But the court eventually has had to struggle with trying to think about what the boundaries of obscene speech are. How do we distinguish between obscenity and other kinds of speech and writings that in fact are constitutionally protected? And that's what we want to talk about today. So we start with William Blackstone, who was an English jurist who was writing just before the American Revolution. He summarized the state of English law as it existed during the period and helped reform that English law as well, and was extraordinarily influential on the American revolutionaries and American founders. They took Blackstone as an accurate summary of what English law represented, and they moreover took Blackstone in particular as he talked about what the scope of government powers were and what kinds of rights individuals have as being laying out the guidepost as to what American constitutional law and American law generally ought to look like as well. And so when Blackstone talks about what freedom of speech and freedom of the press looks like, this is what many American founders assumed freedom of speech and press meant when they wrote it into our Constitution, both the federal Constitution in the form of the First Amendment, but also many state constitutions as well. And what Blackstone emphasized, what of course that the free government, like he thought they had in England, ought to recognize a freedom of speech and freedom of the press. But he thought that meant it was still possible to punish certain kinds of writings and certain kinds of speech, which he thought English law did at the time. And the Americans likewise thought that when they guaranteed a freedom of the press and freedom of speech under their constitutions, likewise, some kinds of speech and some kinds of writings could still be punished. So then the question is, well, what kinds of speech and writings are outside the scope of the First Amendment and can still be punished despite those First Amendment protections? As Blackstone characterized it, the kinds of things that are outside the scope of those protections of freedom of speech and freedom of the press are dangerous or offensive writings, which when published shall on a fair and impartial trial be adjudged to be having a pernicious tendency. And we need to be able to punish those kinds of dangerous and offensive writings that have a pernicious tendency because it's necessary, Blackstone thought, to the preservation of peace and good order, of government and religion, which he thought was the only solid foundations of civil liberties. That if we allowed dangerous and offensive writings that had a bad tendency on society that undermined peace and good order, then ultimately we lose our liberty and lose free government as well. And as a consequence, the state, even a free government, would need the capacity to be able to punish offensive writings. So what counted as dangerous and offensive writings? Well, one kind of thing that Blackstone certainly thought counted as dangerous and offensive writings, and well-trained lawyers of that time period thought counted as dangerous and offensive writings, was offensive, and in some cases, blasphemous, and in other cases, obscene speech more generally. And blasphemy is a good example of a kind of speech that eventually becomes disfavored in the American context and thought of as largely being protected by freedom of speech, but is an example of a kind of offensive speech that early in American history there's real concern that is outside the scope of the First Amendment, and that many states, in fact, would punish. So Chief Justice Kent, who was a very influential jurist in New York State, early in the American Republic in a case called People versus Ruggles, which was decided by the New York Supreme Court in 1811, dealt with one of these blasphemy laws. And what Kent emphasized was that the reason why, even in a free society, even a society governed by freedom of speech and freedom of the press, needed to be able to punish blasphemy was that these kinds of blasphemous statements, things which corrupt moral sentiment, as obscene actions, prints, and writings, and even gross instances of seduction, have been held indictable. And shall we perform an exception in these particulars to the rest of the civilized world, he thought, just because we have First Amendment, just because we have freedom of speech, were we going to be different than every other society that existed in the civilized world? Because every other society, Kent thought, punished the kinds of speech that corrupted the moral sentiment, that undermined morality in the public at large. And he thought that didn't make any sense at all. No government among any of the polished nations of antiquity and none of the institutions of modern Europe ever hazarded such a bold experiment upon the solidity of the public morals as to permit with impunity and under the sanction of their tribunals the general religion of the community to be openly insulted and defamed. Part of why blasphemy, Kent thought, was outside the bounds of constitutional protections was because it would undermine public morality, to have the general religion of the community to be openly insulted and defamed. That kind of offensive speech would tend to be injurious to the morality of the society, injurious to the morality of the young. It would ultimately be corrupting of society more broadly and ultimately undercut free government in the long run. So certain kinds of speech that was subversive of the public morality could ultimately be punished consistent with the First Amendment in order to maintain a free society in the long run. And that was true not only of things like blasphemy, which were offensive to the general religion, but also included things that were against public decency, and that included obscenity. So Chief Justice Tillman, writing Commonwealth v. Sharpless, which was a Pennsylvania Supreme Court case decided in 1816, so not too long after that first case about blasphemy was being decided in New York, emphasized that, of course, acts of public indecency had always been governed by society and could always be punished. So if we went out in public and engaged in sexual acts in public, of course the government could punish us for doing so. And moreover, courts were the instruments by which governments did that. The courts are guardians of the public morals and therefore have jurisdiction of such cases. Hence, it follows that an offense may be punishable if in its nature and by its example, it tends to the corruption of morals. But importantly, Tillman said, that's true even if it's not committed in public. So even if you engage in some behavior that's in private, but it tends to the corruption of the morals of society, the government could still take an interest in those kinds of circumstances. And by analogy, Tillman emphasized that was true not only of public acts of indecency, such as engaging in sexual behavior in public, but it was also true of obscenity. That is, for example, in this case, exhibiting and showing to sundry persons for money a lewd, scandalous, or obscene painting. Tillman's concern here is that that kind of lewd, scandalous, and obscene painting is just as offensive to public morality, just as subversive of public morality as engaging in sex acts in public. And moreover, he emphasized that showing that kind of painting in private was itself also a problem. That you couldn't say, well, just because I'm only showing it in my own house, that somehow it's outside the scope of the law. From his perspective, if you're bringing people in one at a time to look at that painting, it's just as problematic as if you were showing it on the front steps of your house, if you're showing it on the street. That instance of communication, that instance of allowing people to view the lewd, scandalous, and obscene painting was itself going to be damaging to the public morality more broadly. As a consequence, something that the state reasonably had a concern with preventing, and as a consequence was outside the scope of constitutional protection. This was a standard understanding in American law about what the scope of the First Amendment meant, what the scope of your constitutional protections were about speech and press. That while you had a constitutional right to publish all kinds of things, you did not have a constitutional right to publish things that will undermine public morality and subvert and corrupt, especially the youth of the country. And as a consequence, things that had that tendency, things that were obscene, were beyond the scope of the First Amendment. This eventually gets characterized as what's called the Hickman Rule. This was derived from an English case, not an American case originally, but American judges very quickly picked up on this English case that was decided in 1868 and carried it into the American context and said, yes, this is how we understand American constitutional law itself. So in England, the test of obscenity, as it was characterized in Regina versus Hickman, was this: whether the material in question has a tendency of the matter charged as obscenity to deprave and corrupt those whose minds are open to such immoral influences and into whose hands a publication of this sort may fall. That is to say, if you publish something or share something that is depraved and might corrupt somebody, and if they are open to such kinds of influences, that's particularly true of children or the youth, for example, and if a publication of that sort may well fall into their hands, then you could be charged with obscenity. Now, note here that what's important is that possibility that a publication of this sort might fall into the wrong hands and might be subversive of the morality of those who wind up seeing it. Part of what the Hickman Rule is designed to do in this context is to say, well, certain kinds of literary works, they're only going to be exposed to mature audiences, for example, who are less likely to feel the immoral influences of those kinds of works, and is carefully segregated away, so it's not going to fall into the wrong hands, maybe outside the scope of this obscenity doctrine. Or, for example, works that might be used for instruction. So some kinds of works that might be used, for example, in medical training, if they were to fall into the wrong hands, we might think would tend to be depraved and corrupting to the wrong kind of people. But nonetheless, doctors could use those pictures as part of their own medical training. So the Hickman Rule is designed in part to say that certain kinds of works, that if they fall into the hands of people who are open to such immoral influences, then they can be characterized as obscene and as a consequence be punished appropriately. American judges looked at that standard and said, this makes sense of the First Amendment as well, what kinds of constitutional protections exist in the United States, and applied this logic to then how to distinguish between works that are immoral and obscene in the American context and works that are not. And that lasted for several decades. But by the mid-20th century, the court really began to struggle with how to think about this kind of standard. And in particular, their concern was that increasingly literary works were being published for the mass market that were regarded as important works of literature, important works of art, sometimes important scientific works, and were being shared with the general public as a consequence, but included materials within it, included pages, included pictures, for example, included scenes that were potentially corrupting under that traditional standard. And the question then, is that kind of work obscene? And so increasingly a whole set of literary works in particular, so poems and novels were being brought to the United States, often imported into the United States from other countries such as France, and then were being charged as obscene materials that could not be imported into the United States. But these were also works, novels, paintings, poems, that were being celebrated by professors, for example, as being great works of art that were being circulated in Europe, that were being celebrated in Europe. And the question was, can that kind of material be brought into the United States, or did they violate these obscenity laws, or were they protected by the First Amendment? And the court increasingly struggled with the idea that somehow the First Amendment was consistent with the possibility of suppressing great works of literature. So the court was trying to figure out, well, how do we distinguish between great works of literature that might include very explicit sexual scenes, for example, which was of the type that was being written increasingly in the post-war period, from the traditional kind of extreme obscenity that was traditionally excluded from protections under the First Amendment. And the court was not prepared to say, well, we just need to throw out obscenity entirely as a category. The court thought it was important and moreover constitutionally required that we still had an exception for obscenity, that obscene materials were outside the scope of the First Amendment. But the court thought we needed more careful standards, more narrow standards for distinguishing between genuine obscenity that was outside the scope of the First Amendment and the kinds of materials that might be sexually provocative, but was still protected by the First Amendment. And so the court in Roth versus United States in 1957 tries to take this step by saying that it's vital that the standards for judging obscenity safeguard the protection of freedom of speech and press for material which does not treat sex in a manner appealing to a prurient interest. So it's treating sex in a manner that appeals to a prurient interest that the court thought was crucial to what made it into obscene speech. That is, it did not have an artistic purpose, it did not have a scientific purpose, but instead it was simply trying to satisfy people's sexual desires. That's what made it obscene. And so great works of literature that were high-minded were not obscene because they did not appeal to that kind of prurient interest, whereas smut that you bought in the back of a bookstore did appeal to that kind of prurient interest, and as a consequence was outside the scope of the First Amendment, and as a consequence could be punished and suppressed by the government. The court nonetheless found it very difficult to continue to draw that line. And so while they were trying to find a standard that would distinguish between what they would think of as smut and what might be high art, they found, as cases went by, increasing difficulty in making this distinction. And so the court finally settled in Miller versus California in 1973 on a new standard that was more detailed, that tried to articulate the difference between obscene speech and what might be mere pornography or mere indecent speech. And part of what the court was motivated by was community standards. The people in different places might have different expectations about what counted as mere indecency and what counted as obscenity. As the court said it, conduct that was tolerable in Las Vegas or New York City might be intolerable in Maine or Mississippi. And the court thought it was necessary to have a constitutional standard that took account of those different kinds of community expectations about what kinds of speech and what kinds of publications were going to be acceptable within that particular community. So the Miller test had three basic parts, although as you can see, each one of those parts was itself quite complicated. So the court said the basic guideline for the trier of fact must be A, whether the average person applying contemporary community standards would find that the work, taken as a whole, appeals to the prurient interest. So note, it keeps the appeals to the prurient interest. That continues to be the bright line difference between literature and obscenity, was what it appeals to. But here the court emphasizes you need to take the work as a whole, so you can't simply take out a few passages and say, well, this page appeals to the prurient interest and ignore the whole rest of the book. The court emphasizes that page is part of a larger novel, and you have to think about the novel as a whole. Does the novel as a whole, or does the movie as a whole, appeal to the prurient interest? Not just does this particular picture, not just this particular scene appeal to a prurient interest. And moreover, you have to think about the average person applying contemporary community standards. So not what is an extreme case, somebody who's particularly sensitive or somebody who's particularly insensitive, what would they think? But rather, what would the average person think applying those contemporary community standards? Again, what would the average person living in Mississippi think, for example, might appeal to the prurient interest? And that's the relevant standard for thinking about what ought to govern the law in Mississippi. And then B, whether the work depicts or describes in a patently offensive way sexual conduct specifically defined by applicable state law. So again, the focus is on sexual conduct. It has to be patently offensive, and it has to be specified ahead of time in state law. So it had to have very specific standards about what kinds of works would fall within those standards. So the court was requiring state legislatures to be very specific when they drew statutes regulating obscenity as to what exactly the content was that would make something obscene, as opposed to something that was not obscene. So the court could adjudge, and people knew ahead of time what kinds of things they might print, what kinds of things they might sell on a newsstand, for example, that would run afoul of the law. And then C, whether the work, again, taken as a whole, lacks serious literary, artistic, political, or scientific value. So if it has any value of that type at all, then it could not possibly be obscene. Something that had artistic value or political value was by definition protected by the First Amendment because it could not be obscene. It's only something that lacked any serious literary, artistic, political, or scientific value that could possibly be obscene and as a consequence fall outside the scope of the First Amendment. This standard laid down by Miller versus California in 1973 remains the guiding standard for the court in thinking about what the boundaries of obscene speech and obscene publications might be under the context of the First Amendment. The consequences in practice is that very few things count as obscene and outside the scope of the First Amendment, but there definitely are some things that can still be obscene and can still be punished as not falling within those kinds of constitutional protections. But that still leaves the kinds of questions raised by, for example, cases of blasphemy or even indecency more generally. What about offensive speech? That's not necessarily obscene, but nonetheless is a challenge to public morality more generally. And as we saw in the 19th century, the courts are very open to the idea that there were some kinds of indecent or offensive speech that was consistent with, could be consistently curtailed in a way that could be reconciled with First Amendment protections more generally. The First Amendment did not prevent the government from going after speech and publications that tended to subvert public morality, tended to subvert the good order of society more generally. And so often the government could in fact punish speech that was regarded as merely indecent or offensive, as, for example, blasphemy was. But the court over the course of the 20th century became much more protective of that kind of offensive and indecent speech, and for many of the same reasons it's concerned about trying to have a narrower standard for what counted as obscene speech as well. Part of the concern was those standards about what counted as offensive speech, what counted as speech that was subversive of public morality or good order, were increasingly in dispute. And the court was increasingly open to countercultural figures who would say, the kind of speech I'm engaged in, it may be indecent, it may be offensive to public morality, but I ought to be able to offend public morality. I ought to be able to engage in indecency because I need to shake up society. And I shouldn't be bound by the kinds of expectations of morality that the town fathers think might be offensive, for example. I need more freedom to be able to express myself as I want. And the court was increasingly open to those kinds of arguments, that it was too narrow for the government to be able to say, well, in our view, certain kinds of speech is too offensive for people to be able to say in public, it's subversive of public morality, and as a consequence, we ought to be able to punish it. The court wanted to argue, no, those kinds of judgments are going to be biased, they're going to be arbitrary, they're going to suppress all kinds of speech that ordinary people in society want to engage in and ought to have a proper right to engage in. And so the court increasingly shrunk down the scope of that kind of offensive and indecent speech that was constitutionally protected. And among the implications of that kind of shift in our understanding of the First Amendment that developed between the 19th century and the 20th century was things that we might now characterize as hate speech fell under First Amendment protection. So this was most clearly articulated by Justice William O. Douglas in the case of Terminello versus City of Chicago in 1949. Terminello was a very provocative political figure, a former priest who gave a variety of anti-Semitic speeches all through the country and would often lead to riots and mob violence as a consequence of those speeches. He often sought to be very provocative, so he would go into Jewish areas, for example, in order to give these speeches. He was often very sympathetic to fascist movements more broadly, and there were counter-protests that would be mobilized against his speech. And the city of Chicago was one of the places in which he brought these kinds of lectures, and a riot broke out at his public speech. The city of Chicago, like police in many places, tried to deal with the riot by arresting the speaker for having inflamed public passions to such a degree that people engaged in violence as a result. This became a First Amendment case that eventually went up to the U.S. Supreme Court, and the U.S. Supreme Court said governments can no longer do this. When people are motivated to violence as a consequence of the very offensive things the speaker is saying, that's no longer an excuse consistent with the First Amendment for arresting the speaker under those circumstances. The person who is guilty of disturbing the peace under those circumstances is not the speaker who said the offensive things, it's the people who react to the speaker who says the offensive things. So as Douglas says, a function of free speech under our system of government is to invite dispute. It may indeed best serve its high purpose when it induces a condition of unrest, creates dissatisfaction with conditions as they are, or even stirs people to anger. Speech is often provocative and challenging, and the First Amendment was designed precisely to protect that kind of speech that was provocative, challenging, and sometimes stirred people to anger. And so the government had a responsibility to protect even that kind of speech that people would be so angered by they might be provoked to violence. But not all the justices agreed that this was a good idea, that this was a proper understanding of the First Amendment. So Justice Robert Jackson, for example, wrote in dissent in that very case that we have to bear in mind what the actual consequences of protecting this kind of speech was going to be. And he thought the experience of Europe leading up to World War II and the rise of fascism in Italy and Nazism in Germany should be a warning to the American system as well. So as Jackson said, we must bear in mind also that no serious outbreak of mob violence, race rioting, lynching, or public disorder is likely to get going without the help of some speech making to some mass of people. A street may be filled with men and women, and the crowd still not be a mob. Unity of purpose, passion, and hatred, which merges the many minds of the crowd into the mindlessness of a mob, almost invariably is supplied by speeches. So from Jackson's perspective, those kinds of speeches, the speeches that create mobs, the speeches that create mob violence, are themselves extraordinarily dangerous. And government had a responsibility to be able to protect people from that kind of mob violence. And in order to protect people from mob violence, you need to be able to nip it in the bud. You need to be able to prevent the mob violence before the actual violence breaks out, which means you had to go after the speaker that was inciting those mobs in the first place. So from Jackson's perspective, the worry that he had about how this court was expanding the First Amendment to protect this kind of deeply offensive speech was it was going to create a situation in which there was going to be street violence on a routine basis. Mobs and counter mobs were going to form just like they had in Europe, in which they were going to be fighting in the streets, and the government was going to have its hands tied and make it more difficult to prevent that kind of street violence from breaking out because they could not prevent the kind of hateful speech that gave rise to that kind of street violence. And from Jackson's perspective, this would ultimately be damaging to democracy. If people did not have faith that the government could prevent that kind of violence on the streets from breaking out, they would ultimately lose faith in democracy itself, and they would turn to strong men who were capable of preventing that kind of violence from occurring. So from Jackson's perspective, it was very important then that we not understand the scope of free speech to be so expansive that included the kind of speech that might lead to mob violence. Jackson, though, was on the losing side of that kind of argument across the 20th century. The court became increasingly protective of that kind of hateful, indecent, offensive speech. And this arose in all kinds of contexts, not only the kind of offensive anti-Semitic speech that was at stake in the Chicago instance, but also cases like Cohen versus California in 1971. In this case, someone who was unhappy with the draft as it was being pursued during the Vietnam War era wore into a courtroom a jacket with a slogan emblazoned on the back of the jacket that denounced the draft with particularly offensive language. The court then punished that person for wearing such a jacket into the courtroom with that kind of offensive language on it. This became a First Amendment case, which went to the U.S. Supreme Court. And the U.S. Supreme Court emphasized that that kind of offensive language, even on the back of a jacket and even in a courtroom, could not be punished consistent with the First Amendment. As the court was looking at the 1960s and 1970s, it was increasingly convinced that this kind of civil disagreement as to what kinds of language might be offensive could not be an area in which the government could intervene. We had to understand that a wide range of speech had to be constitutionally protected because ordinary people engaged in a wide range of speech in order to express their views. So as Harland famously characterized it, while the particular four-letter word being litigated here is perhaps more distasteful than most others of its genre, it is nevertheless often true that one man's vulgarity is another man's lyric. Indeed, we think it is largely because government officials cannot make principal distinctions in this area, the Constitution leaves matters of taste and style so largely to the individual. If you think that the only way of expressing your views about the draft require that you use four-letter words in order to express it, it was not up to the government to say, that's beyond the bounds of the First Amendment. You should be able to use your four-letter words to express your political message. And the government cannot tell you that that's too offensive to matters of taste or style, are too much likely to give offense to others or undermine public morality for you to engage in that kind of speech. Indecent speech had to be protected in order to allow ordinary people to express their views in public. But that extends ultimately as well to disparaging speech. So as the court quite recently held in the case of Mattel versus Tam, which involved a provision of American trademark law, which is what kinds of protections you could provide to certain kinds of business symbols or business marks that could be protected. And Mattel versus Tam involved a punk rock band that wanted to use a racial slur as part of their band name. In this case, a racial slur directed toward Asian Americans. It was an Asian American punk rock band that wanted to reappropriate the term for their own purposes. And the government said, you can't trademark that band name because it violates this provision of the trademark law, which prevents the government from giving trademarks to disparaging language. And the band brought its suit to court and argued it had a First Amendment right to get a trademark for its offensive band name, precisely because it, as a band, should have the freedom to be able to choose offensive speech as part of what it's doing. And the court agreed, said, yes, that kind of disparaging speech is protected by the First Amendment. So as Justice Samuel Alito, one of the more conservative members of the modern court, said, giving offense is a viewpoint. The government has an interest in preventing speech expressing ideas that that offend. And as we have explained, that idea strikes at the heart of the First Amendment. Speech that demeans on the basis of race, ethnicity, gender, religion, age, disability, or any other similar ground is hateful, but the proudest boast of our free speech jurisprudence is that we protect the freedom to express the thought that we hate. So even hateful speech directed at particular races or religions or disability groups, for example, is still going to be protected by the First Amendment, is not outside the bounds of the First Amendment, and as a consequence was going to be protected. So the upshot, as constitutional law has developed across the 20th century in particular, is that obscenity remains unprotected by the First Amendment, but obscenity has been significantly narrowly defined and will not include mere indecency. So the scope of what counts as obscene speech has to be understood very narrowly, so that a great deal that was thought to be obscene in the 19th century is no longer understood to be obscene for First Amendment purposes. But offensive speech is not protected by the First Amendment. Offensive speech is protected by the First Amendment, which means, for example, that there is no hate speech exception to the First Amendment, that threats, harassment, and incitement to violence are not protected, but they all are narrowly defined. So there are some very specific things we might think as very hateful speech, things that include harassment, for example, things that actually incite violence. Those things might be outside the scope of the First Amendment, but the court has restricted to very narrow scope as to what counts as that kind of speech. Because broadly speaking, speech that's merely indecent, speech that's merely disparaging, speech that's merely offensive, no matter how much it might undermine public morality, no matter how offensive and disturbing government officials might find it, for example, that speech is nonetheless protected by the First Amendment because government officials can't be the monitors to determine what speech is going to be regarded as too offensive, too indecent to say. The government officials can't be the ones to determine what kinds of speech are outside the bounds of good taste and good decency.